Joining me in studio, Nate Monroe, Metro columnist at the Florida Times-Union. Nate is perhaps second only to federal prosecutors when it comes to knowing the backstory of the JEA debacle. For those of you tuning in, have you been following the federal criminal case against the former JEA executives? What questions do you have about what's happening in the case? Give us a call, 549-2937, tag us on X at FCC On Air, or send us an email to firstcoastconnect@wjct.org. You can also message us on Facebook and Instagram. So good morning, Nate. Thanks for being here.
It is a pleasure.
It is a pleasure to have you. So there were some major developments in the case this week. I'm going to ask you to tell us about that in just a minute. But first, give us a reset on the case. Remind us what this criminal case is about and how it started.
Yeah, sure. As a lot of listeners will probably recall, there was a little bit of a controversial effort several years ago to privatize JEA, to sell it to a private operator. JEA is a city-owned electric, water, and sewer utility, one of the largest in the United States. And the two of the individuals who led that privatization campaign, JEA's former CEO, Aaron Zahn, and CFO, Ryan Wanamaker, were indicted in March of last year on allegations that they essentially tried to skim profits off the top of that sale. Of course, the sale never did happen, and they never did actually get any sort of payouts, but federal prosecutors think that plan went far enough to justify conspiracy and fraud charges.
And their charges are tied to the sale attempt because they would have essentially benefited had the utility been sold.
Yeah, I mean, that's the rough way to think about this, and I may be stripping away a little bit of nuance, is to say that they were going to skim profits off the top of a sale. So a sale would have been in the billions of dollars range, and federal prosecutors believe that the profits they were going to extract out of it could have been in the hundreds of millions of dollars range.
And so these two gentlemen are charged with conspiracy and wire fraud. They've both pleaded not guilty. So the criminal investigation began under the auspices of the sale or because of this plan that they were going to skim, allegedly profit from?
So we know now that federal prosecutors and FBI agents actually started looking at JEA in late 2019 and did not specifically start looking at it because of this, kind of bonus plan that sort of ended up forming kind of the heart of the indictment. That was, I don't think, initially why they started looking. I think they started looking because there was just a lot of acrimony and outcry in the community about how the sale was being done. It was very secretive. It was all moving very fast. There were, the stakes were really high. Again, there were billions of dollars at stake here. And so I think just the kind of controversial nature of it is what put it on their radar. And it was not until early 2020, March, April, that I think they started developing a theory about this profit skimming bonus plan.
And the way that whole issue rolled out, it was the controversy of the sale. Even at the meeting where they, voted the JEA board to pursue the idea of privatization, this bonus plan was sort of buried in that meeting, almost like a footnote. And it seems like the investigation also followed a similar pattern.
Yes, I mean, the entire case revolves around the July 23rd, 2019 Board of Directors meeting where privatization was authorized. And at the very, very end of the meeting, the board did greenlight this kind of opaque, what looked like an employee incentive plan. Prosecutors have since said, and I think there was a lot of coverage and a lot of other sort of non-criminal investigations of this meeting that preceded the federal case. A lot of people came to believe that Zahn and Wanamaker essentially disguised a very lucrative bonus plan as an otherwise pretty harmless technical sort of employee incentive program.
Mm-hmm. So that brings us up to the current issue, the case. So there was a decision this week. In May, you and I spent, it seemed like an eternity in hearings.
It was 8 days.
8 days. 8 days in federal court is, I think, in like human years, probably like at least 6 weeks, right?
At least, yeah.
But those hearings, the defendants in the case hoped that they would scuttle the case. Essentially, they were asking the judge to say that this indictment was illegitimate. So tell us what's going on with that now.
Yeah, I mean, this was, I think, the the hearing was the culmination of like the primary pretrial strategy that the former CEO and CFO were sort of making to head off this indictment, or at the least to get the current prosecutor kicked off the case. I mean, they were looking for any sort of way to tie prosecutors' hands or weaken the case. So just to say up front, the issues at the core of this recent decision are a bit complicated. There's not a really super easy way to explain this, but there is anyone who's watched a police procedural or a courtroom drama knows what it means to plead the fifth. You have a Fifth Amendment right against self-incrimination. There is a legal concept called Garrity rights. Garrity rights essentially extend that Fifth Amendment protection to government employees. Just listeners, take my word for it that there are times when government employees do not really enjoy Fifth Amendment protections the way that everyone else does. There are times when they can be compelled to sit and comply with like administrative or internal investigations and answer questions that are asked of them and answer them fully and truthfully, whether they incriminate them or not. Courts have said that those kinds of statements and those kinds of contexts cannot be used to prosecute them in the future. Zahn and Wanamaker sat for Garrity interviews near the end of their tenures at JEA. The board had asked city attorneys to conduct a workplace investigation, and both of them spoke with city attorneys for hours and hours. Zahn actually sat for 2 days. And so what they were essentially arguing was that federal prosecutors had likely used material from these protected statements that they provided to build their criminal case, or that knowledge about what was said in their interviews somehow like tainted the entire case. Because, and you'll remember this, the transcripts of their interviews became public records. And so, ordinarily Garrity protected statements don't get like really reported on, and they don't get publicly disseminated. And so that was kind of the big dispute at the core of this like 8-day hearing that you and I sat through.
And so they were saying because the prosecutors were aware of this, privileged or otherwise not admissible, testimony that they'd given, that their entire investigation was tainted and not legitimate.
That's right.
And so the judge says what?
The judge issued, a magistrate judge issued a 103-page decision
this week
on Monday that essentially said, the prosecution in that 8-day hearing successfully demonstrated that it marshaled evidence totally independent of those Garrity statements, and that to the extent even if you assume there was some tainted evidence, there is enough independent evidence of wrongdoing to justify this indictment. He made lots of credibility findings about the government's witnesses, and he really, and there are portions of this ruling that are redacted, but I think pretty thoroughly picked apart a lot of the defense's arguments and essentially said, look, making theoretical connections between Garrity protected statement and what the evidence in the indictment is just not enough.
So case is still on for trial as it currently stands. When is that?
February.
And you'll be there?
Of course.
How long is it going to last?
I think the trial could very well last about a month.
All right. Merit badges for Nate Monroe, Metro columnist at the Florida Times-Union. Thank you so much for being here and updating us on the case.
Of course, anytime.
All right.